Ladies and gentlemen of the jury, as I told you in the statement, Mr. Bordire, that I wouldn't get to speak with you again until closing the session. So we arrived at that time now. I want to first thank you. As I stated to Bordire, this is one of the things that makes this country great. When a person is accused of a crime, that they have the right to have a trial by one's peers in the community. It makes this country great. It makes it unique in the world, and for that I'm grateful. I'm grateful for your attention. I've noticed you throughout the trial. You've been taking notes. You've been diligently listening to the evidence and weighing the evidence as you hear it. And so I just want to thank you for this. And also, you've got a large responsibility on your hands. After I'm done, you're going to go back, 12 of you will go back in the jury room, and you'll decide this case. And I want you to know now that whatever decision you make, I'll respect that decision. And because I know that you've been attentive, and I know that you've listened. Now I want to talk to you about where I believe, or what I believe the evidence was in this case, and what I believe should be done. With that, I'll get started. Everybody see this? Ladies and gentlemen, I'd first like to start off by addressing the money injury. There's been accusations leveled towards Kelsey Wallace that she was responsible for the death of her own daughter. Kelsey Wallace, in this case, took the stand. She sat right here. And with Mr. Garrett standing right next to her and directing pointing questions to her, asked her did she harm her child. What was her response? I did not harm my child. I did not harm my child. I did not hurt my child. Your Honor, ladies and gentlemen of the jury, there's been no proof whatsoever introduced besides the statement of the defendant that Kelsey Wallace hurt her child. Ladies and gentlemen of the jury, she took the stand. She was there to testify. You were able to see her as she testified. Defense counsel has characterized her as a vexing vixen who masterminded all of this. Who, after her child was dead, she came up with this elaborate plan to cover up her child's death. The problem is, there's been absolutely no proof offered to show this. He says there's Clorox wipes in the house. Ladies and gentlemen, there were two-year-old children in this house. Is it abnormal that there have Clorox wipes in the house? Where they were located, they were on a kitchen table and on the stairs. Ladies and gentlemen of the jury, there were cleaning supplies placed all over the house. So I request that you look at the picture, look at the evidence, see the condition of that house, and see that it wasn't abnormal for there to be Clorox wipes on that table. And there's been absolutely no proof that she used those Clorox wipes to wipe anything off. The other day, Deputy Bowe and I were talking, and he had a statement. He said, it's possible that a tornado can blow through a junkyard and build a Greyhound bus. That might be possible, but it's not probable. So ladies and gentlemen of the jury, all this business about Clorox wipes, yes, it may be possible, but it's not probable. It's not proven. Then they go to the prosecuting attorney's sister. Said that she helped Kelsey cover all of this up. Ladies and gentlemen of the jury, she was here today. She took the stand. She testified. No one helped this up. All I did was tell her, you need to call in an Amber Alert, and you need to report the car missing. This was after she had been informed by her family that Laney was missing. Ladies and gentlemen of the jury, is that unreasonable? No, it's not. There's been absolutely no proof that Kelsey deleted any phone calls, deleted any text messages. Your Honor, and ladies and gentlemen of the jury, Anthony Barbour, Kelsey Wallace are guilty of bad news. They're both admitted to negligence. And because they admitted to using meth, does not make Kelsey a killer. It does not make her big issue was that she trusted the defendant. When the defendant came home on that Sunday and told her that her child was over at Shana's house and was going to be there to play, and then later said that the child was going to spend the night, she trusted her. And that was her mistake. And again, there's absolutely no physical evidence in this case implicating Kelsey. He wants to refer to a hair found on this safe. The testimony was that hair was taken from the safe, taken to the Kentucky State Police Lab, then taken to the forensic lab in Frankfort, Kentucky. From there, it was sent to the FBI lab in Quantico, Virginia. And he's saying, well, the measurements are off. I believe the testimony was one was 12 and 7/8 inches, and one was 32.4 centimeters. Now, I believe Mr. Garrett's conversion is correct. They might be off by a 0.3 of a centimeter. Everybody's seen the ruler. Everybody's seen that measurement. 0.3 of a centimeter. It's the same hair. And what does that hair tell you? That Kelsey Wallace was excluded as a source of that hair. John Stewart did mitochondrial DNA testing, and he testified that Kelsey Wallace and Randy Wallace can be excluded as sources of that hair. Ladies and gentlemen of the jury, the defendant has also confirmed Kelsey Wallace's behavior. And it's not just the broad strokes, it's the detail. You heard his statement to the Kentucky State Police. In there, he said, yes, we went arrowhead hunting. I came back to the house, Kinley, Kelsey, and I. We went arrowhead hunting, and Kinley noticed that the boots were wet. Why were the boots wet? Because he'd taken Laney out that morning. He also said, I left the back door open. I believe he stopped back in the house on Monday. Kelsey Wallace told the Kentucky State Police that he snuck back in the house and the back door was open. It's the details that he confirmed, not just the broad strokes. Turn now to the evidence of the defendant's guilt, because he's the one on trial. Ladies and gentlemen of the jury, you have direct evidence that the defendant is the one who is responsible for laying his kid out. His own admission. You've heard him say, I don't know, say, guilty for all that I have done. You heard him tell the Kentucky State Police that on the bluff after he was apprehended. You also heard him say, Laney is in heaven because of me. You also heard him admit that he took Laney with him on that Sunday morning. They left the house. Ladies and gentlemen, he does give a story about falling off the bluff. And I would submit to you that story is probably false. I also submit to you that he offered this story to minimize his responsibility in this matter. He had killed this child, and he was trying to minimize his responsibility. We also know that Laney had acute traumatic injury. The medical examiner testified about what acute traumatic injuries mean. They mean they happened before death and they hadn't had time to heal. She had head injury. She had a laceration on her skull. She had a hemorrhage on the back of her head. And she possibly had a black eye as well. Redness on her eye. Bruising. There were also injuries to Laney's genitalia. He said those were acute as well. They had happened sometime recently before her death. And ladies and gentlemen, no, Mr. Anthony Barbour is not charged in this case with rape, sodomy, or sexual abuse. And the reason is because I can't prove to you beyond a reasonable doubt that he committed rape, sodomy, or sexually abused a child. That's why that charge wasn't brought. But also, it is noteworthy when you have a child that's found naked, lying in the bottom of the well with injuries to her genitalia. Because the medical examiner testified in this case. And he says, I can't rule it in, and I can't rule it out. It could have been sexual abuse. And again, her body was found naked in the bottom of the well. We also know that there were forcibly removed hairs found in this case. And Laney's blood was also found. Where was it found? Ladies and gentlemen of the jury, the stickers on this piece of evidence marked where Laney's blood was found. It was confirmed by DNA testing. The hairs, Jack Reed stated, came from a pink lip from this area of what they call the window frame. Not in the floorboard, not in the floorboard. And ladies and gentlemen of the jury, this is also the front passenger side of this car. It's not the back seat where Anthony says that the child was placed in the car after she'd been hit by her mother. There was no blood found back there. It was lost. There's no question about that. But ladies and gentlemen of the jury, as I stated before Dyer about honest mistakes, this was an honest mistake. It wasn't an intentional act, and it didn't deprive the defendant of anything. Why? The defendant, his counsel, turned the shirt over to Kentucky State Police for testing. They could have had their own expert test the shirt if they wanted to. Maybe it was their right objection.